Well, for many green card applicants, Advance Parole, it has been an important travel document. You have a pending adjustment of status application. You need to travel outside the United States. You receive Advance Parole and you believe that you can travel and return while your green card application, well, that continues. But, ladies and gentlemen, according to TimesXP's report, with a lot of research by the way, a new Board of Immigration Appeals decision, well, it has dramatically changed the legal landscape altogether. The decision, described as the matter of Delcarmen-Lara, reportedly overturned the protection that had expired under an earlier 2012 decision known as matter of Arrabally and Arrabally. You know why that matters? It matters because the legal definition of leaving the US, that could become extremely important when somebody has previously accumulated unlawful presence. In fact, the report also explains that more than 180 days of unlawful presence, it can trigger a 3-year ban after departure, while 1 year or maybe more than that, it can potentially trigger a 10-year bar. Now, if we talk about the older interpretation, some people using Advance Parole, they were protected from triggering those particular bars simply by traveling. Well, the new ruling described in the report, it changes that understanding now. And this creates a very serious warning here. An approved Advance Parole document that does not automatically ease your immigration history at all. That's a misconception now. Ladies and gentlemen, if somebody has a very complicated history of status gaps, overstays or unlawful presence, international travel, it can become a much bigger legal question now. And that is why this is not a story where one simple piece of advice applies to everyone. Two people can both hold Advance Parole. One may have a clean immigration history, another may have a long period of unlawful presence here. Well, their risk can be completely different. Adding more than the report, it also says the ruling applies prospectively, meaning that previous travel completed before the specified date, it may be treated differently. But for people planning travel now, message is very clear. Do not assume that holding a travel document that automatically means travel that is risk-free now. Well, immigration law is extremely fact-specific. Dates matter, status matters, previous applications matter, and sometimes one trip can affect an application that has taken years to build. So, before traveling internationally, somebody with a pending immigration case and a very complicated status history, they should get case-specific legal advice. You know why? Because this is not a situation where a social media post or a 5-minute online video can replace professional legal review.